Right, so welcome Juliana. Welcome to the Rev Room. Why don't you tell the viewers what your position is and what do you do at LabourNet?
Okay, perfect. So hi everyone. My name is Juliana from Merwe and I've been with LabourNet for 6 years now. Currently a consulting labour law team lead. So basically it's very long, I know, but basically what it means is I take care of an entire team and we specifically focus on labour law compliance. So to making sure all our clients are compliant with contracts, policies, procedures, running disciplinary procedures, whatever you might need or
That's a lot. So it sounds a very important job you've got, Juliana.
Yeah, and I really enjoy it. I have an awesome team. I'm actually from Cape Town, so I manage the team on that side, but also in George, and I absolutely love my job. I mean, every day is a challenge. And I think why I say that is because no day is ever the same. So every single day, you don't know if the client phones you, what's going to be on the other end of the line, what's the questions that they're going to ask. And I really, really like working in an environment where I can think on my feet and I can help people to solve problems.
Wow, that's quite different. And it seems quite a lot of pressure for you, is it?
Yeah, I guess you can say it's a very big responsibility. I think that's the right word. Not a lot of pressure, but it's a big responsibility because the clients, they put all their trust in us to make sure if something is either referred to the Bargaining Council or CCMA, that they've ticked all the boxes and that there's no adverse arbitration awards or no losses on their end.
Got it. Okay.
Yeah, so it's a big responsibility, but I mean, you're either born for it or you're not.
Okay, and you seem to be born for it.
Yeah, no, definitely. There's no questions on that.
Okay, great. So you mitigate risk with it
basically
every day.
Yeah, and ensure compliance. So whatever we do is we ensure compliance and we mitigate risk as far as possible. But if you've already made a mistake, then we'll still help you out to, like you said, mitigate it.
Cool, to mitigate it a little bit further. Or
Yeah.
A little bit or limit the risk.
Yeah, at least.
Cool. So Juliana, that's great. I love the energy. I love the fact that you love your job, which is really great because it is your second home or your first home almost sometimes.
No, I think it's my first home.
Is it?
Yeah.
Thanks for being honest. So a lot is changing in our landscape in South Africa. Loads of things are changing. And so tell us a little bit about what's changing in the labour space.
So the changes that I've mentioned, like I said, the Code of Good Practice, Schedule 8 more specifically, sets out your procedures that you're required to follow before you dismiss an employee. Okay? So it normally stipulates progressive discipline should be applied, meaning you need to issue warnings and you need to follow a fair procedure, so you need to give sufficient notice, representative, and all of that. Usually the code only made provision for dismissals based on misconduct, so that's your disciplinary hearings, and your dismissals based on incapacity for ill health or performance, which is your poor work performance. But now the updated code actually includes operational requirements as well. So it's always been in legislation, but it sets out nice guidelines for employers to make sure that they still comply with Section 189 of the Labour Relations Act in terms of dismissing employees for operational requirements.
Okay.
Further to that, the new code also gives us a template version, I almost want to say, of your Section 189 Notice of Intention to Retrench. So companies can now use one template instead of drafting their own templates, or in some cases, some companies might not even be aware of the fact that they're required to draft notices. So this code sets that out and it really guides employers on what to do with that. The one other change that came into effect is that of the parental-leave. So we used to have 4 months maternity leave unpaid for the mother and then the 10 days consecutively unpaid for the father, and we obviously had the adoption and commissioning parents leave. Now they've changed it completely. They've made it 4 months and 10 days if two parents are both employed either by different employers or the same employer. So if we were to have a child, it's 4 months, 10 days between the two of us. We can split it. I can take the entire 4 months and 10 days, whatever the parties agree to. And then if you are the only parent working in that specific relationship, then you will become entitled to 4 months. So I think companies just need to make sure they update policies, they review their contracts, they update their contracts as well, because it's something that the Department of Labour will look out for when they conduct their audits.
That's big. So you now have to go and change everything.
Basically, yeah.
Everything.
Yeah.
Wow. Okay.
Yeah.
Perfect. And it sounds quite reasonable. It sounds like it's a good thought-out process.
So they've actually considered it for quite some time. I know it was referred to the Constitutional Court quite some time ago, but we only got the ruling, or they only issued the ruling on the 3rd of October. I do understand the principle behind it. It's just to make sure, because in some instances the mother might be earning a higher income, or so I understand the circumstances around it and the rationale as to why they've made a decision, and I think it's just moving with times. And then the other change is it now makes provision for a topic that we also deal with quite often, and that is imprisonment. So what to do if your employee is in jail. The code now makes provision in terms of how to deal with an employee that's imprisonment. So it's part of an incapacity, but it sets that procedure. And then a common question that we also get often is incompatibility. So basically, when an employee doesn't really fit within your culture, how do you get rid of that person? So there's no element of misconduct that you can focus on, but it's more cultural problem. Then you focus on incompatibility, incapacity, and this code sets out an incompatibility, incapacity, what the requirements are, as well as the procedures to follow. So I think they've updated the code quite a bit to help employers and guide them a little bit more.
But that's actually quite great, because I mean, being in the space, in the entrepreneurial space for years, I mean, most guys don't actually understand what's happening from the labor perspective, and is a hit and miss unless someone is employed the likes of LabourNet to look after them. So, but I mean, having forethought, in my opinion, if the legislation has now made provision for a cookie cut template, it actually sounds great. It does,
but obviously I still think it's important that companies put their own kind of identity to it and not just use the blanket approach in terms of this is the template, because remember, every retrenchment, and I'm just using retrenchment as an excuse or as an example now, but every retrenchment will have a different rationale. So you're still going to be required to draft that section 189 notice in a way that is in alignment with the rationale behind the retrenchment. Your alternatives will be different from another company. So yes, sets out the guidelines, but I still think you need that touch just to make sure that it's in alignment with your requirements.
Got it. So they need the LabourNet touch.
They still need the LabourNet.
The LabourNet
touch. Definitely.
Got it. Cool. No, that sounds great. And so if one of our listeners are wanting to reach out to LabourNet or to talk about a service and or assistance in this regard,
yes, please. They can contact us. We can probably share our contact details, but we will help them all the way. And I also think it's a great opportunity because the Code of Good Practice also refers to progressive discipline and the importance of applying progressive discipline before you merely dismiss an employee. Obviously, in some certain
take a breath.
In some scenarios, you would have an immediate dismissal for like theft, fraud, those serious types of cases. But in other instances, for example, poor timekeeping or unauthorized absence, the code really emphasizes the importance of applying progressive discipline. So I think it's a good opportunity for companies to also just review the disciplinary code, make sure you are applying progressive discipline in areas where you're supposed to, but also that you're quite strict in terms of your harassment cases or fraud, dishonesty, those type of cases. And obviously LabourNet can assist with reviewing your disciplinary code as well. So
win-win.
Yeah, definitely.
Cool. Juliana, thanks for joining us in the Rev Room. We really appreciate your time and your valuable input. We'll definitely have you on the Rev Room again. So thank you for joining us.
Thanks.
For the viewers, if you've liked, please subscribe. If you'd like to have a question, we'd love to communicate with you. We'd like to point you in the right direction to talk to the professionals, and let's start a conversation. Thank you.